next. Jussie Smollett's attorney, Tamara Walker, and I will talk one-on-one. The former Empire actor was recently found guilty of lying to police about a hate crime. We will talk about Smollett's upcoming sentencing and appeal. Stay with us here on Court TV, your front row seat to justice.
We're obviously very disappointed. We obviously respectfully disagree with the jury's verdict. The verdict is inconsistent. You cannot say Jussie is lying and Jussie is not lying for the same exact incidents. So we feel 100% confident that this case will be won on appeal. Unfortunately, that's not the route we wanted, but sometimes that's the route that you have to take to win, especially a case where we remain 100% confident in our client's innocence.
That was some of Jussie Smollett's defense team addressing reporters following his guilty verdict last month. A Chicago jury deliberated for more than 9 hours over 2 days before finding the actor guilty of 5 of the 6 charges against him. Those charges are some of the least serious felonies in the state of Illinois, but he still faces 3 years in prison. His attorney, Tamara Walker, joins me today. And before we discuss this case, I'd like to listen first to what the state had to say after the verdict.
During my closing argument, I told the jury that I thought the evidence was overwhelming, that in fact Mr. Smollett had faked a hate crime and then lied to the police about it, and then compounded his crimes by lying to the jury during the course of this trial and insulting their intelligence. That's what I told the jury in my closing argument. With the resounding verdict we just received from this jury after 1 day of deliberations, in which they found Mr. Smollett guilty of virtually all charges of doing exactly what we said he did, of reporting a fake crime to the Chicago Police Department as a real crime, that verdict was a resounding message by the jury that, in fact, Mr. Smollett did exactly what we said he did. And what I think is important about this verdict is that a lot of you from Chicago know that it was a couple years ago when the court system came to me and wanted me to become special prosecutor because there was a feeling that things that had happened in the past, that there never was a public trial, and that this controversial events that occurred regarding Mr. Smollett and what he did to this city and what he did to the Chicago Police Department never had a chance to put it in front of a jury and let a jury decide, after hearing all the evidence, whether what Mr. Smollett was right or wrong, because it's very controversial. I agreed to do that because I felt it was also important for the Cook County judicial system to get a trial. Whether we won or lost the trial was not the issue. What was the issue is that what Mr. Smollett had done in this city should be aired in front of a public trial where all the evidence that comes out, all the talk on social media may or may not be true, but the true facts, I thought, needed to come out, and we did it. And we became special prosecutors, and the rest is history. We've now won this case, and I want to point out that there's an enormous effort was put in when I agreed to take the special prosecutor role. That meant that my law firm became special prosecutors, and the men and women around me right now in the last 2.5 years have worked so hard to develop the evidence, present it to a grand jury, go through a pandemic, wait to get a trial, which we wanted, and finally, in the last 10 days, these lawyers have had a chance to present this evidence to a jury, and we've come away with the jury agreeing that they should have heard the case, and in fact, he was guilty. Thank you very much.
Tamara Walker with me now. Thank you for talking about this case with us. I saw you on the first press conference standing at the podium as they were all speaking. So let me ask you, what is your reaction when you just watched the prosecutor talking about overwhelming evidence? What's your position as one of the members of this defense team?
Well, I appreciate the opportunity to address this question. As it pertains to this case, as you know, we still have sentencing ahead of us. And we still have a number of post-trial motions that we'll be bringing to address what happened during the trial. What's interesting, though, from what Mr. Webb was speaking about during the press conference, is that This was a case, and I don't want to make the comparison, but it's similar in some ways to Bill Cosby in terms of contractually what happened. What I mean when I say that is when the case was initially dismissed by the Cook County State's Attorney's Office, that was with reason and it was done in a binding fashion. For the case to then be rebrought, as Mr. Webb went into great detail about his office, his law firm that's quite large in size, to come on as special prosecutors after such an agreement is highly unusual and needs to be examined.
So how did that happen? And let me just preface, I recognize that it is sentencing and their post motions and appeals. So certainly if I ask anything, I know you well enough to know you'll say, I really can't talk about any of that. But I must ask, how in your opinion did it happen that you're right, that from everything we've seen and read, that it was dismissed by Cook County? And typically when it's dismissed in the right way, it means they can't bring those charges again. But in this case, that happened.
What happened was procedurally, a motion for a special prosecutor to prosecute the case was brought, and it was granted by a Cook County judge, and this is where we found ourselves. So, of course, it's extremely unusual, and it's something that we challenged as Mr. Smollett's defense team, and it's something that I anticipate the appellate court may examine.
And how was Mr. Smollett doing at the time? I want to start backwards and then work forwards, but at the time of this sentence, watching the passion of the defense team as you all spoke, and you were nodding your head that he was not guilty, he hadn't done this. And so the passion that exists there, how did he respond and react and handle the fact that it was a guilty verdict?
Well, he stood strong. He was obviously disappointed. However, he had his whole family around him who were very supportive, very, very extraordinary, outstanding individuals. All of his siblings, his mother was there every day, which at times had to be challenging. So I think he handled it as well as anyone. I mean, in a moment like that, forget being a Hollywood actor or a singer or anything else. You're a person dealing with the reality of your life being tremendously impacted in a way that few people could ever imagine.
Yeah, no, I agree with that. Anytime there are criminal charges and then a guilty verdict against anyone, I don't think you can really truly embrace or imagine what that means. Let's talk then about sentencing. Let's move forward to that. We know that sentencing is supposed to happen this month. Are there any updates you can give us about when that might be expected, first of all?
Well, no, actually, there is a status date set this month. Sentencing is not expected until March. There are some things in Cook County. There is a pre-sentence investigation report that has to be done. There's other things that have to happen. So no, it won't be this month.
All right, so the status is this month and then the sentencing in March. And are you able to share, just from the overall criminal justice perspective, of what might happen at that sentencing hearing and what you can expect might be presented by each side in dealing with the sentencing phase?
Well, in a situation like this, we had a full-blown trial. So both sides have presented pretty much everything there is to present. A lot of it now is going to rest in the hands of Judge Lynn. So we will have to wait and see, but we're certainly preparing from a mitigation standpoint, meaning for factors that are favorable to our client. We're certainly working hard. And we're also, working with the prosecution. This isn't a scenario where we don't have a relationship with the prosecution in terms of being able to speak with them and make sure that everything is happening towards the greater good. That's why we have the status date. So we're working behind the scenes, we're working in front of the scenes, we're doing everything that we can to make sure that the sentence is reflective of what happened.
And I consistently talk about as trial attorneys, all of us as trial attorneys, you work all the time. I mean, it is not something where it's in a month,
Exactly.
we can get to it then. It's a constant.
Exactly.
All right, Tamara, you're going to stay with us. There's so much more we're going to talk about the sentencing and Jussie Smollett's conviction. We do have to take a quick break, but more discussion on the other side.
Does your friend need an ambulance?
I just think he's startled. What's really weird, ma'am, just because I'm scared, I don't know what it is. They put a noose around his neck. They didn't do anything with it, but it's around his neck. That's really up to me. Sorry for saying it like that.
Welcome back to Court TV Live. I'm Ashley Wilcott, a continuing conversation with one member of Jussie Smollett's defense team, Tamara Walker, who you're not just a member of that defense team, you're a legal analyst, a criminal defense attorney. You were talking to us on Court TV about other cases, so I recognize your expertise, but I know right now we're really talking about the Jussie Smollett case. You did mention a status hearing is this month for the sentencing. The sentencing is expected in March, but what else, if anything, did you have to share with us about the sentencing aspect of this case?
Well, you know, being a part of this broadcast today has really brought to light the fact that there's several serious cases going on in this country. And as you said in introducing this segment, you know, Mr. Smollett is charged with class 4 felonies, and those are the least serious felony offenses. It's a level above a misdemeanor here in Illinois. So I think that, you know, we should definitely keep that in perspective as we move towards a sentencing posture. I mean, you know, we're talking about Ghislaine Maxwell, we're talking about Halderson, who dismembered his parents, we're talking about the unfortunate case with Mr. Edgecombe. So I just want to make sure that the viewers understand and put what actually happened with Mr. Smollett's conviction in perspective, in the perspective that it deserves, given the climate that we have right now.
And in fact, if I have all my facts right, there's a possibility that he won't have to serve jail time in terms of what's allowed under the law. Is that correct? Because of the nature of the guilty conviction and what it's for. Is that right?
That is absolutely correct. While there is a sentencing range, I think one of your, either you or someone in the package mentioned that it could be up to 3 years. The range of sentencings for a class 4 felony is 1 to 3 if it's a penitentiary sentence. However, it is probation eligible. It is probation eligible all day long. And there's also what we have is a diversion program for people who have limited to no criminal history that they qualify for. There are a number of different programs at disposal. There are a number of different sentencing options. And we just hope that Judge Lynn is able to exercise that mercy and give a sentence that's reflective of the offenses charged.
And that is the same judge, as I understand it, that heard the evidence, as you mentioned, in the trial. So we talked a little bit earlier as legal analysts about the fact that the judge has heard the evidence, has heard all of it. And so the benefit to that, I believe, is that they get the whole picture of information that's out there in addition to anything else that may be argued in motions or presented during sentencing. But I think then they have the whole picture of, just to your point, the severity or not of different convictions.
Exactly. That's perfectly stated. Couldn't have said it better myself.
Well, I have to tell you, it's a joy to talk with you because of your knowledge and breadth of experience, and you know what you're doing. All of our legal analysts do. It makes it easy to have the conversations because I want to pivot now and to an appeal. And it is my understanding, I know that we've heard here at Court TV and your team has stated, the defense team has stated that you will appeal. What is the latest? Is there anything you can share with us about the appeal process or where it is?
Oh, well, you know, we are really just past this case. Right now, we are preparing for post-trial motions. Basically, our verdict came in right before the winter break. So we're kind of gearing back up now that we're into a new year, new posture. And we're getting the official transcripts, all of the kind of boring lawyer things that go into making sure someone's rights are represented after a guilty verdict. So the post-trial motions are moving forward, and we look forward to making certain that the appellate court examines what happens and justice is served.
And look, I'm a trial nerd, so I love every aspect of our criminal justice system. But I'm going to say this and see whether or not you agree. Appeals are tedious for the reason you just said. It is getting the transcript. It is looking at every word. It is looking at every possible grounds for appeal because that's the right that a person has. You need to protect their rights even after a guilty conviction. And so I recognize the importance of it. I can't underscore it enough, but it's a tedious process to make sure you look at every detail.
Absolutely. Absolutely. You said it correctly. So first, there comes post-trial motions. And, you know, as those proceed, then we see about what happens with the appellate court. But we are definitely looking forward to making sure that the record is examined, that post-trial motions, you know, some of them we brought before trial, and we'll be looking to rebring some of those and basically introduce what happened in court as a part of them. And so we're very much looking forward to having everything examined and making sure that, again, the appellate court agrees that justice was served here.
And I have two more areas I'd like to touch on, but first I must ask post-trial motions. How would you describe or define that for viewers who may not be familiar with that language?
Great. I appreciate that opportunity. So post-trial motions are, once a trial is over with, if there's a guilty verdict, you bring up motions to the judge. And motions are just simply requests. So we're asking, Judge, can you look at this portion? We feel that this didn't happen properly. Judge, can you re-examine this portion of the trial? We feel that what the prosecution said made it seem as if the defense had a job they didn't have. So those are the types of things that happen once a guilty verdict comes in. There's a number of post-trial motions that we anticipate here. So I appreciate that opportunity.
Okay, absolutely. Then I think the last question we have time for, and I've enjoyed talking with you about this, but what is your reaction to the lawsuit that Jussie Smollett is facing by the city of Chicago to recoup $130,000?
Well, myself and my team are not a part of that, and I don't really want to speak on ongoing litigation.
All right. Thank you so much, Tamara. I so appreciate you. You're going to stay on as a guest legal analyst, but I appreciate your taking this time to speak to us about that case, knowing that sentencing is coming up and scheduled in March. Coming up next.